Okay, so here we are again. We're focused on Amy Coney Barrett. This is part 3 of 3, hopefully. Possibly 4, but hopefully we make it through enough today to kind of get a full rounded feel for who she is. Um, Today, I would like to focus on her balanced life, how she chooses to balance it. I'd like to look into how she compares to other Supreme Court justices, and also we need to finish up her previous cases. Um, we kind of made it through a few of these on the left here. So we had made it all the way through criminal procedure, I believe. Nope, we didn't even make it that far. We made it through employment discrimination. We had started on immigration and worked against helping immigrants to receive benefits temporarily and a lower status of income. Let's see if we can figure out where that was. So I can see I clicked Chevron. It was a landmark case in which the United States Supreme Court set forth the legal test for determining whether to grant deference to a government agency's interpretation of a statute which it administers. I have no idea what that means. But yeah, so today we're looking to pretty much finish off what we expect to learn about Amy Coney Barrett. So far, I really actually can appreciate her as a Supreme Court justice, and I think that she will do a fantastic job into the future. She seems very balanced, which is crazy, and that's why I really want to get into her personal life, because I don't know how she can manage 7 kids and have such a high status job like this. So with that, let's get into it. All right, so let's look back at immigration a little bit. In June 2020, Barrett wrote a 40-page dissent when the majority upheld a preliminary injunction against Trump administration's controversial public charge rule, which heightened the standard for obtaining a green card. Her dissent, she argued, that any non-citizens who disenrolled from government benefits because of the rule did so due to confusion about the rule itself rather than from its application, writing that the vast majority of people subject to the rule are not eligible for government benefits in the first place. Okay, so she argued that non-citizens who disenrolled from government benefits because of the rule did so due to confusion about the rule itself. Let's look at the public charge rule. Under the public charge rule, immigrants to the United States classified as likely or liable to become a public charge, which we learned last time that a public charge is someone who is like kind of taking from the social like benefits. May be denied visas or permission to enter the country due to their disabilities or lack of economic resources. So I kind of hold a little bit of difficulty with this, because likely or liable to become a public charge, like how do you quantify that, and how political can that get? But regardless, she wrote like a really long paper on the majority upheld a preliminary injunction against. Okay. So they're disagreeing with this rule, and she's disagreeing with the disagreement of that rule. Okay, that's interesting. I'm not sure what we can take from that, other than the fact that essentially there's people who are going to require some sort of jump start, like whether it be training or something else. It seems to me somebody is going to need a jump start in order to start producing something or being useful, basically. And we're trying, it sounds like we're trying to avoid allowing those people into our country, because we don't want them to just come into our country and then leech off of what is here. And it sounds like that she was against that rule. So the Supreme Court was majority trying to not allow that rule, and she was against the majority in that situation. She wrote a paper about it. Let's go ahead and put that in our notes. Wrote a 40-page dissent on disagreeing with the majority who were trying to stop what is that rule called? The public charge rule. And let's do a quick definition of that. So the public charge rule is that denying visas to those immigrants that are likely going to cost, I guess you could say America in this case, money rather than be helpful. Basically people who actually need help, it seems to me. Okay, we should probably label these because we have immigration here. She brought justice to a case, Purdue Joe. So that was Title IX of the Education Amendments of 1972. No, that wasn't. Was that employment discrimination? That's AutoZone. Okay, willing. Yeah, that's okay. So this first one is let's underline that. Also, let's like make it the same. We don't want it bold. And you don't want the whole thing bold. Come on, OneNote. Work with me here. Okay, so there's that guy, and then we have these two, which are under the employment discrimination. That's annoying. Okay. And 11. This one 12, that one is 12. Okay. Okay, so we've got those. Those are some pretty big ones. I think Title IX of Education Amendments of 1972. Not many people are looking at that as like a hot button situation. I have never heard of that. Then again, I'm not in like political spheres, but at the same time, I've never heard of that. I can imagine employment discrimination being kind of a big thing. I definitely think that immigration in this last presidential term was a big thing. A lot of people using that as a reason why they don't like Trump. So let's move on to abortion-related cases. This one's kind of a touchy subject for our household. Not because we have personally experienced it, but because we just really feel a certain way about it. So Barrett has never ruled directly on abortion, but she did vote to rehear a successful challenge to Indiana's parental notification law in 2019. In 2018, she voted against striking down another Indiana law requiring burial or cremation of fetal remains. In both cases, Barrett voted on the minority. The Supreme Court later reinstated the fetal remains law, and in July 2020, it ordered a rehearing in the parental notification case. Okay, hold on. Barrett has never ruled directly on abortion, but she did vote to rehear a successful challenge to Indiana's parental notification law in 2019. So she's challenging the law. In 2018, she voted against striking down another Indiana law requiring burial or cremation. She voted against striking down. Okay, so she wants burial or cremation. Let's look up parental notification law. That sounds pretty interesting. Okay. Judges critical of Indiana law notifying parents of teen abortions. Oof. That's rough. The Seventh Circuit, this is a really rough subject. The Seventh Circuit had harsh words Friday for an Indiana law guaranteeing pre-procedure notification to the parents of underage teenagers who are seeking abortions. That makes sense. Okay. This totally makes sense. Mostly because a kid, a teenager, is still under, like, technically, the parent is still responsible for that kid. And man, this is hard, but I think that the kid is still a kid, and that is a big decision, and I don't think that this law is intended to get them in trouble or something like that, something ridiculous like that. It's just about the parents being notified so that they can have a conversation with their kid about what they're about to do. Okay, I kind of agree with that. Not that that's what this is about, but we can say that she was wanting to rehear a challenge to that law, and so she wanted that law, and there was a challenge to the law, and she wanted to rehear that so that she could vote on it. It sounds like she voted against striking down another Indiana law. Okay, so in the case that the abortion does happen, she wants to have a proper honoring of it. In both cases, Barrett voted with the minority. The Supreme Court later reinstated the fetal remains law, and in July 2020, it ordered a rehearsing of the parental notification case. A rehearsing. In February 2019, Barrett joined a unanimous panel decision upholding a Chicago bubble ordinance that prohibits approaching within a certain distance of an abortion clinic or its patrons without consent. Citing the Supreme Court's buffer zone decision in Hill v. Colorado, the court rejected the plaintiff's challenge to the ordinance on First Amendment grounds. Hill v. Colorado. Hill v. Colorado was a United States Supreme Court decision. The court ruled 6-3. First Amendment right to free speech was not violated by Colorado law limiting protest, education, distribution of literature, or counseling within 8 feet of a person entering a healthcare facility. So yeah, as long as you're counseling outside of 8 feet, you're good. Okay, that's pretty funny. I can just imagine like someone rolling up behind or in front of someone, just screaming at him like, "I'm counseling you." Okay, anyways. In response to protesting at abortion clinics, Colorado legislated that protesters within 100 feet of any healthcare facility may not approach within 8 feet of any other person without consent for the purpose of protest, education, distribution of literature, or counseling. Okay, so essentially they're just trying to protect people who are going into healthcare facilities and that includes abortion clinics. Whether or not that should be considered a healthcare facility, I'm not sure. Okay. She was trying to join a unanimous panel decision upholding a Chicago bubble ordinance that prohibits approaching within a certain distance of an abortion clinic or its patrons without consent. So she wanted to uphold that. That's interesting. Okay, so she wants there to be space in the case that, so she's protecting the people even if she doesn't agree with what they're doing. That's cool, actually. Okay, so in abortion-related cases, she has never ruled in one of these, but has taken measures to protect families for example, voting to have parents of pregnant teens be notified of request for abortion. And I think that I truly think that even though it's going to be a difficult conversation for the parties involved, I think that is aimed at helping families more than it is aimed at like making a teenager uncomfortable. So, and then she also upheld a bubble ordinance. So she protects those entering a healthcare facility by upholding the bubble law. We'll call it the bubble law. We know what we're talking about. So control underline. Second Amendment. Ooh, this is another big one. Okay. I'm going to say that criminal procedure is probably not a huge one. Environment is definitely a big one for me. Consumer protection, not really worried about that. Coronavirus measures. So we're going to go Second Amendment, environment, and coronavirus measures. Environment and corona. And then after that, we can finally get on to the most important thing, which is how the heck does she manage her life? I don't understand. 7 kids. That's so many kids. Supreme Court Justice. Man, you gotta have a pretty scheduled life. All right, Second Amendment. In March 2019, Barrett dissented when the court upheld a federal law prohibiting felons from possessing firearms. Barrett dissented when the court upheld a federal law prohibiting felons from possessing firearms. Okay, she's trying to get felons to be allowed to have firearms again, it sounds like. The majority rejected the as-applied challenge raised by the plaintiff, who had been convicted of a felony mail fraud, and upheld the felony dispossession statute as substantially related to an important government interest in preventing gun violence. In her dissent, Barrett argued that while the government has a legitimate interest in denying gun possession to felons convicted of violent crimes, there is no evidence that denying guns to non-violent felons promotes this interest, and that the law violates the Second Amendment. All right, I like that. Protected. Not that it matters what I like. Okay, so she guarded a guarded a citizen's Second Amendment right by stating that the felony he had committed was nonviolent and the law aimed at preventing felons from having firearms. Was not okay. By stating that the felony he had committed was nonviolent and that the law aimed at preventing felons from having firearms is more appropriate for felons with violent crimes. I like that. That was a good one. I appreciate her doing that, actually. All right. We're moving right through these. Killing it. Environment. This one's I'm really interested in. In Orchard Hill Building Co. versus U.S. Army Corps of Engineer 893, Barrett joined a unanimous panel decision written by Judge Amy J. St. Eve in a case brought by a property developer challenging the Corps' determination that a wetland 11 miles from the nearest navigable river was among the waters of the United States. The court found that the Corps had not provided substantial evidence of a significant nexus to navigable in fact waters under Justice Kennedy's concurrence in the Supreme Court's decision in Rapanos versus United States. The case was remanded to the Corps to reconsider whether such a significant nexus exists between the wetlands in question and navigable waters for it to maintain jurisdiction over the land. So essentially the Army Corps of Engineers is saying that we do own this wetland because it's a part of navigable rivers, but really that it is 11 miles away from the nearest navigable river, and thus the Supreme Court said that it wasn't valid. Joined a unanimous panel decision written by Judge Amy J. St. Eve in a case brought by, okay, so she joined the unanimous panel decision. What was the decision? The case was remanded. I need to figure out that word. Remanded. Place on bail or in custody, especially when a trial is adjourned. Return a case to a lower court for reconsideration. The case was remanded to the Corps to reconsider whether such a significant nexus exists between the wetlands in question and navigable rivers for it to maintain jurisdiction over the land. So instead of ruling on it, she pushed it back down to the Army Corps of Engineers to ask whether or not we can actually determine that as our let's look at what the waters of the United States are. The Clean Water Rule is a 2015 regulation published by the U.S. Environmental Protection Agency and the United States Army Corps of Engineers to clarify water resource management in the United States under a provision of the Clean Water Act of 1972. The regulation defined the scope of federal water protection in a more consistent manner, particularly over streams and wetlands, which have a significant hydrological and ecological connection to traditional navigable waters, interstate waters, and territorial seas. It is also referred to as the Waters of the United States Rule, WOTUS, which defines all bodies of water that fall under U.S. federal jurisdiction, which defines all bodies of water that fall under U.S. federal jurisdiction. The rule was published in response to concerns about lack of clarity over the Act's scope from legislators at multiple levels, industry members, researchers, and other science professionals, activists, and citizens. The rule was contested in litigation. In 2017, the Trump administration announced its intent to review and rescind or revise the rule. The Supreme Court ruling on January 22, 2018 returned the rule's nationwide authority after the rule was decided to be illegal by a lower court. It gave back jurisdiction previously complicated by decisions from circuit courts of appeals. 2 weeks later, the Trump administration formally suspended the rule until February 6, 2020. The Trump administration formally repealed WOTUS rule on September 12, 2019. The Trump administration formally repealed the WOTUS rule on September 12, 2019. Okay, so it's gone, it sounds like. What is the point of this thing, though? I don't understand what the point of this is. The United States to clarify water resource management in the United States under a provision of the Clean Water Act. Okay, so let's go back and look at an Orchard Hill Building Company versus the Army Corps of Engineers. Barrett joined. Who are these people? St. Eve, Circuit Judge. This case concerns just shy of 13 acres of wetland, which lie in a south suburban plot of land called the Warmk Parcel. Orchard Hill Building Company purchased the Warmk Parcel in 1995 with plans for large-scale residential development. Not wanting to run afoul of the Clean Water Act, Orchard Hill requested a determination from the United States Army Corps of Engineers that the wetlands, or Warmk wetlands, were not jurisdictional waters of the United States. The Corps decided that they were, and Orchard Hill has spent the last 12 years challenging that decision. Okay, so what I'm getting at here is that we have a fight between a corporation and the government is trying to protect the wetlands, it sounds like. Background. A braid of regulatory, judicial, and administrative events led to the Corps' final claim for jurisdiction over the Warmk wetlands. We start at the beginning. Congress enacted the Clean Water Act in 1972 to restore and maintain the chemical, physical, and biological integrity of the nation's waters. One of the Act's primary means to that end is its general prohibition on polluting navigable waters, which it defines as waters of the United States. The Act imposes significant criminal and civil penalties for such pollution, and obtaining a permit to build on or near such waters can be a lengthy and costly process, yet the Act does not define what constitutes waters of the United States. That job falls to the Corps of Engineers and the Environmental Protection Agency, and it has proven a contentious and difficult task. To take a recent example, the agency's attempt in 2015 to redefine the statutory phrase resulted in a new administration's swift overhaul and a slew of litigation. Executive Order 13778, restoring the rule of law, federalism, and economic growth by reviewing the waters of the United States. Rule 82, definition of waters of the United States, addition of an applicability date to 2015 Clean Water Rule. This case, however, concerns... Okay, so I think I get an idea of what is happening here. We've got the Army Corps of Engineers, who are responsible for saying what waters should be protected in the United States. And we have a corporation who is saying that we don't want to build here because we're worried that we're going to hit protected waters and that we might pollute those waters, and that could cause a lot of problems for us. And if we go back to what we were talking about here, it sounds like she joined a unanimous panel decision to basically push it back down to the lower court, which then eventually was taken away. So in the end, this was, environmentally speaking, this ended up being against the environment. But I can't say that Amy Coney Barrett is responsible for that. She just chose to push it back down to a lower court. So really, she didn't defend or aggressively attack environmental things. She kind of left it up to other people. I'm going to say a hands-off approach. It sounds actually pretty reasonable. Takes a hands-off. All right. So, coronavirus measures. In early September 2020, Barrett joined Wood's opinion upholding the district court's denial of the Illinois Republican Party's request for a preliminary injunction to block Governor B.J. Pritzker's COVID-19 orders. Joined Wood's opinion upholding the district court's denial of the Illinois Republican Party's request for a preliminary injunction. Wow, that's a lot of logical back and forths there. There we go. All right. Is there a background on this guy? I like that last one that we looked at, and it had a background, like immediately following the introduction. As the coronavirus SARS-CoV-2 has raged across the United States, public officials everywhere have sought to implement measures to protect the public health and welfare. Illinois is no exception. Governor J.B. Pritzker has issued a series of executive orders designed to limit the virus's opportunities to spread. In the absence of better options, these measures principally rely on preventing the transmission of viral particles from one person to the next. Governor Pritzker's orders are similar to many others around the country. At one point or another, they have included stay-at-home directives, flat prohibitions of public gatherings, caps on the number of people who may congregate, masking requirements, and strict limitations on bars, restaurants, cultural events, and the like. These orders and comparable ones in other states have been attacked on a variety of grounds. Our concerns here is somewhat unusual. Governor Pritzker's executive order exhibits special solicitude for the free exercise of religion. It does so through the following exemption. Free exercise of religion. This executive order does not limit the free exercise of religion. To protect the health and safety of faith leaders, staff, congregants, and visitors, religious organizations and houses of worship are encouraged to consult and follow the recommended practices and guidelines from the Illinois Department of Public Health, as set forth in the IDPH guidelines. The safest practices for religious organizations at this time are to provide services online in a drive-in format or outdoors, and consistent with the social distancing requirements and guidance regarding wearing face coverings, and to limit indoor services to 10 people. Religious organizations are encouraged to take steps to ensure social distancing, the use of face coverings, and the implementation of other public health measures. Emergency and governmental functions enjoy the same exception. Otherwise, E043 imposes a mandatory 50% cap on gatherings. The Illinois Republican Party and some of its affiliates believe that the accommodation for free exercise contained in the executive order violates the free speech clause of the First Amendment. In this action, they seek a permanent injunction against E043. In doing so, they assume that such an injunction would permit them to congregate in groups larger than 50 rather than reinstate the stricter ban for religion and some of the governor's earlier executive orders included, though that is far from assured. Relying principally on Jacob v. Massachusetts, the district court denied the Republicans' request for preliminary injunctive relief against E043. The Republicans promptly sought interim relief from that ruling, but we declined to disturb the district court's order, and Justice Kavanaugh, in turn, refused to intervene. We did, however, expedite the briefing and oral argument of the merits of the preliminary injunction, and we heard argument on August 11, 2020, guided primarily by the Supreme Court's decision in Winter v. Natural Resources Defense Council. We conclude that the district court did not abuse its discretion in denying the requested preliminary injunction, and so we affirm its order. Wow, okay. So basically this is just aimed at allowing more than 50 people to be in one place, and it sounds like the Governor Pritzker actually put a clause in there for religious gatherings. I'm not sure what the purpose of going against this would serve. Yeah. Okay, so Governor Pritzker sounds like he's trying to defend his people, and the Republican Party is saying, no, we don't care about that. We would like to gather in more than 50 people, and this is ridiculous. And the district court basically just denied that, and it went to the Supreme Court, and the Supreme Court upheld that district court's decision. Okay, so she is for saving people and thinks it's possible she's following the science, and it's possible that she thinks that the science is right. This is a positive for me. Again, not that it matters what I think. Went with a district court's decision to socially distance people and in a court decision in a what? In a trial where the Republican Party of Illinois was trying to block a executive order from Governor. Is it Governor? No, dang it. Oh, I missed the R. Governor. From Governor Pritzker. Is that his name, Pritzker? I think it is. Yeah. That limited gathering more than 50 people in one place. One space, we'll say. Semantics. Okay, so that's all of her previous cases. Not all of them, but a pretty good summary of them. Okay, so we have what I'm really interested in, which is how does she balance her life? But before that, okay, we have previous cases marked off the list, which is great. Feeling good about that. We should verify information elsewhere. I'm going to keep that on the list, but I'm going to say it's optional. I haven't really been, like, from what I've read off this wiki, I haven't really read anything that seemed really leaning one way or the other, so I think we're pretty safe to assume that these things are objective. Okay, so the most important question is how does she balance her life? But before that, let's do a really quick just Supreme Court justices. Let's take a look at the bench, and let's just look at their backgrounds real quick. Okay, Chief Justice of the United States, John G. Roberts. Was born in Buffalo, New York, January 27th, 1955. He married Jane Marie Sullivan in 1996, and they have 2 children, Josephine and Jack. Okay, so first off, the Chief Justice has 2 kids. He received an AB from Harvard College in 1976 and a JD from Harvard Law School in 1979. He served as a law clerk for Judge Henry J. Friendly of the United States Court of Appeals for the Second Circuit from 1979 to 1980. Okay, when did he make it to Supreme Court? And as a law clerk for then Associate Justice William H. Rehnquist of the Supreme Court of the United States during the 1980 term. He was Special Assistant to the Attorney General, U.S. Department of Justice from 1981 to 1982, Associate Counsel to the President Ronald Reagan, White House Counsel's Office from 1982 to 1986, and Principal Deputy Solicitor General, that's a crazy title, U.S. Department of Justice from 1989 to 1993, from 1986 to 1989, and 1993 to 2003. He practiced law in Washington, D.C. He was appointed to the United States Court of Appeals for the District Columbia Circuit of 2003. President George W. Bush nominated him as Chief Justice of the United States, and he took his seat September 29th, 2005. Okay, so our Chief Justice served in the Court of Appeals for the Second Circuit from 1979 to 1980. So when he ended his time there in 1980, it took him all the way to 2005 to make it to Supreme Court. So let's pull up some calculator magic here, and let's subtract out. So 2005, that's 5. 1980, I don't know why I pulled up the calculator. It's pretty obvious. Okay, so 1980 to 2000, we have 20 years, and then 2000 to 2005, we have 5 years, so we have 25 years. It took him 25 years to make it to the Supreme Court. Not that that was always his aspired dream, but still there's quite a bit of gap between when he actually became a judge of one of these circuit courts and when he was nominated and affirmed in 2005. All right, next up, Clarence Thomas, Associate Justice, was born in Pinpoint Community near Savannah, Georgia on July 23rd, 1948. He attended Conception Seminary from 1967 to 1968 and received an A.B. cum laude from College of the Holy Cross in 1971 and a J.D. from Yale Law School in 1974. He was admitted to law practice in Missouri in 1974 and served as an Assistant Attorney General of Missouri 1974 to 1977. Okay. Assistant Attorney General. And attorney with the Monsanto Company. Oof. 1977 and 1979. That name has a lot of weight in my head. I think it has to do with agriculture. And I think I've seen possibly a couple documentaries on it. And legislative assistant to Senator John Danforth. 1979 to 1981. From 1981 to 1982, he served as a Assistant Secretary for Civil Rights, U.S. Department of Education, and as a chairman of the U.S. Equal Employment Opportunity Commission 1982 to 1990. From 1990 to 91, he served as a judge on the United States Court of Appeals, District of Columbia. Okay, so 91. President Bush nominated him as an Associate Justice of the Supreme Court, and he took a seat in 91. Interesting. So this guy did it the same year. Okay. So we have one for Amy Coney Barrett is different, and we have one for Amy Coney Barrett's actually pretty moderate. Stephen G. Breyer, Associate Justice, was born in San Francisco, California, August 15th, 1938. He married Joanna Hare in 1967 and has 3 children. Okay, so we've got the closest to Amy Coney Barrett's children count is Stephen G. Breyer. He received an AB from Stanford University, a BA from Magdalen College, Oxford, and an LLB from Harvard Law School. He served as a law clerk to Justice Arthur Goldberg of the Supreme Court of the United States during the 1964 term, as a special assistant to the Assistant U.S. Attorney General for Antitrust 1965 to 1967, as an assistant special prosecutor for the prosecutor of the Watergate Special Prosecution Force, 1973. That's another name that I certainly think holds a little weight. Watergate. As special counsel of the U.S. Senate Judiciary Committee, 1974-1975, chief counsel of the committee, 1979 to 1980. He was an assistant professor of law, and lecturer at Harvard Law School, 1967 to 1964. Okay, let's from 1980 to 1990, professor of the College of Law, Sydney, Australia, and at the University of Rome. This guy's all over the place. From 1980 to 1990, he served as a judge of the United States Courts of Appeals for the First Circuit and as its chief judge, 1990 to 1994. Okay. He also served as a member of the Judicial Conference of the United States, 1990 to 1994, and of the United States Sentencing Commission, 1985 to 1989. President Clinton nominated him as an Associate Justice of the Supreme Court, and he took his seat in 94. Okay, so we've got, where did he enter? Served as a judge of the United States Courts of Appeals for the First Circuit from 1990 to 94. So this guy took 4 years. Okay, so he's on par with Amy Coney Barrett. Excuse me. Okay, he has 3 children, and he made it from appeals court to Supreme Court in 4 years. Again, on par with Amy Coney Barrett. Samuel A. Alito, Jr., Associate Justice, was born in Trenton, New Jersey, April 1st, 1950. He married Martha Ann Baumgardner in 1985 and has 2 children. Okay, 2 children. Where did he join circuits? Court of Appeals for Third Circuit in 1990. George W. Bush nominated him for Associate Justice of the Supreme Court, and he took his seat January 31st, 2006. Okay, so we've got 90 to 2006, 16 years. Okay. On par for time between. None of these people have like a crazy amount of kids like her though. Okay. We've got Sonia Sotomayor, Associate Justice, was born in Bronx, New York on June 25th, 1954. She earned a BA in 1976 from Princeton University, graduating summa cum laude and receiving the university's highest academic honor. Yep. 1979, she earned a JD from Yale Law School. I'm having trouble speaking. Where she served as an editor of the Yale Law Journal. She served as an assistant district attorney in New York County District Attorney's Office from 1979 to 1984. All right, I'm gonna start crushing this a little bit more. So we've got President George H.W. Bush nominated her for the U.S. District Court, Southern District of New York, and she served in that role from 92 to 98. Okay, so she made it to the Second Circuit in 2009, and Barack Obama put her up for associate. Okay, so she moved up pretty quick from courts of appeals to Supreme Court. Elena Kagan, how many? There's a lot of these people. I don't see Amy Coney Barrett on here. Am I reading the wrong ones? Justices, circuit assignments, Supreme Court at work. Why is Amy Coney Barrett not in here? Oh, she is. She just has nothing under her name. That's kind of sad. Okay. Anyways. Elena Kagan, Associate Justice, was born New York, New York on April 20th, 1960. She received an AB from Princeton. How many kids does she have? Does she have kids? She became she served. I don't think she has kids. No kids. Where is her? Between 2003 and 2009, she served as Dean of Harvard Law School. In 2009, President Obama nominated her as the Solicitor General of the United States. A year later, the president nominated her as Associate Justice of the Supreme Court. So it took her a year to get noticed and then pushed into the Supreme Court. She did... Oh, here we go. She clerked for Judge Abner and for Justice Thurgood. So at most, she helped. She didn't actually serve in any kind of circuit court. That's interesting. Neil M. Gorish. So she actually, I think, okay, moving back. I think that she is exemplary of the same behavior that we see for Amy Coney Barrett, where she moved into the Supreme Court very quickly. And really, from what I'm gathering, that's actually pretty normal for the justices. Or associate justices, I should say. Okay. So Neil M. Gorish. Does he have any kids? Doesn't look like it. At least they don't announce it. Oh. He and his wife, Louise, have 2 daughters. Okay, so he has 2 kids. Court of Appeals for the 10th Circuit in 2006. So in 2006. And then in 2017, he came to... So we've got 11 years, right? 11 years between circuit court. He served in the circuit court for 11 years before he moved up to the Supreme Court. So he has experience. I feel pretty good about that. I have not researched him. Brett Kavanaugh. Kavanaugh actually sounds like a pretty heavy name. I have definitely heard that name. I don't know what it is, but I've heard that name. He was born in Washington, D.C. on February 12th, 1965. He married Ashley Estes in 2004, and they have 2 daughters, 2 kids, Margaret and Lisa. He received a BA from Yale College. Okay, so he served as a law clerk for a bunch of people. He was an attorney in the office of the Solicitor General of the United States. Still no circuit. He was assistant to the president and staff secretary for President Bush. He was appointed a judge of the, okay, there we go, Districts of Columbia in 2006 and pushed into, wow, President Trump has had a lot of opportunity to fill the seats here in the Supreme Court. In 2018. So we've got 2006 to 2018. That's 12 years. So he's had 12 years of experience before making it to Supreme Court. And then we have Amy Coney Barrett. And this is kind of sad because, like, there's no information here regarding her. But we can answer our question here. Is Amy Coney Barrett... I really hope that I'm saying that name right this whole time because it would be embarrassing if not. Is Amy Coney Barrett's rise to Supreme Court normal? I'm going to put in parentheses, it seemed kind of fast. And the answer to this is yes, pretty normal. All right, we've answered it. I'm going to say yes, pretty normal, but no one... Gosh, my headphones turn off sometimes. But no one else has anywhere near 7 kids. It's insane. So many kids. All right. Now, for the piece de la resistance. I think that's how you say that. How does she manage her life? It's kind of crazy. And we're going to go... if there's no place here. Oh, there is a personal life section. In 1999, Barrett married fellow Notre Dame law school graduate Jesse M. Barrett, a partner at South Bank Legal, Ladue Curran LLC in South Bend, Indiana, and a law professor at Notre Dame Law School. Previously, Jesse Barrett had worked, the couple lives in South Bend and has 7 children, 2 of whom were adopted from Haiti. Okay, so... I'm going to go ahead and start a section for this. So they have 7 kids, and 2 of them are adopted. Oh, she saved it. Oh man, 2010 Haiti earthquake, and their youngest biological has Down syndrome. Oh no. That's hard. Barrett is a practicing Catholic. She was raised in Christian prayer church community, People of Praise, and ecumenical covenant community found in South Bend, associated with the Catholic Charismatic Renewal movement, but not formally affiliated with the Catholic Church. About 90% of its approximately 1,700 members are Catholic. In People of Praise, Barrett has served as a lay pastoral women's leader. Barrett has voted in both Republican and Democratic primaries. She tested positive for COVID-19 in the summer of 2020 and has since recovered. Wow. Okay. That's a lot. 7 kids, 2 adopted, and 1 with Downs. Is that how you spell that? Downs syndrome? Down syndrome. That's really sad. Okay. Now we're going to go probably to a little bit more of a gossipy side. She is a Catholic, it sounds like. And really does sacrifice for the whole. I don't want to say sacrifice for the whole. She is Catholic though. And let's look at have I been spelling her last name with 1 T? Ah, geez. Okay. 2 T's. I don't know. 2 T's. Okay, I don't think there's anyone else. How does Amy Coney Barrett manage her life? That's the question. How does Amy Coney Barrett do it? Jen.medium.com. Let's see what they have to say about this. The October 3rd broadcast of Saturday Night Live opened with a debate spoofs featuring Alec Baldwin as President Trump and Jim Carrey as the Democratic rival, former Vice President Joe Biden. Okay, we don't care about that. We want to know about her. What? Okay, this is weird. That got weird fast. Ridden Faith. Amy Coney Barrett represents a new conservatism. On a winter afternoon in 2018, Judge Amy Coney Barrett rose to speak in Notre Dame Law School's wood-paneled courtroom and thanked the people gathered there for joining her for her official investiture as judge of the United States Courts of Appeals for the Seventh Circuit. I really want to know. Yeah, let's look at that. What's Amy Coney Barrett's childcare secret? She should let us in on it. Before he landed a role in Marvel's Eternals, was the everyman, a slouchy nerd who seemed a lot like the character he played on Silicon Valley, at least fitness-wise. Then overnight, he showed up on my Twitter feed, chiseled, oily, and okay. What happened? Why couldn't I get in amazing shape? What is this? These moments of transparency lift the veil of illusions of perfection created by wealth and access. None of these are answering my question. Which brings me to Amy Coney Barrett. Her working husband and their 7 children. Let me start off by saying that I don't think that Barrett's family life should determine whether she's qualified. It doesn't. To which she was confirmed Monday. Indeed, some of the questions surrounding her nomination have been sexist and antiquated, like when Senator John Neely Kennedy asked, "Who does the laundry in her household?" And I'm not here to discuss her politics. However, I fervently believe that Barrett's vague answers around her own child care situation are hurting moms in America, working moms, stay-at-home moms, moms who wish they could be working more, moms who wish they could stay home more. Okay. During Barrett's nomination ceremony, she said that her community knows her more as a room parent, carpool driver, and birthday party planner than a judge. How does she do it? In the same speech, Barrett credited... Okay, I just want to see the speech. I don't give a shit about your commentary. Let's just Google this. I said a bad word there. Sorry about that. Fearless Babysitters. Amy Coney Barrett. Let's look for videos. I want to make sure that you guys can hear this too. I don't think you guys can hear this. You definitely can't. Okay. Nothing is being said. It's just piano music with people's faces. Okay. That was unhelpful. These articles are such a waste of time. Similarly, during 2019 interview in Notre Dame Law School, she said that her husband and her husband's aunt, along with a flexible workplace and living in a small town, enable her to pursue a demanding career while being present for her family. Okay, so she's saying that her husband and her husband's aunt, along with flexible workplace and living in a small town. Okay, so basically people are like, yeah, you're a good person and we'll help you out. Even though you have a demanding career, you're really not asking that much of us. I have some absolutely wonderful friends in my life, friends who would drop everything to watch my children in an emergency. But as wonderful as they are, I cannot imagine them watching my 7 children for 40 hours a week so that I can work. I cannot imagine asking the babysitters I've used, while also wonderful, typically quit once they find full-time nannying gigs that compensate them better than the measly 4 hours a week that I pay them for. I also have a wonderful family and lovely aunts, but as helpful as they are, they have lives of their own. They do not enable me to work 40 hours a week. This isn't Amy Coney Barrett saying this. Is there a possibility that Barrett raised 7 children without consistent, high-quality childcare? I have no interest in judging... Okay, well then stop judging here. Does Amy Coney Barrett have like a LinkedIn? Do I have to log in for this? I do. Does she have a Facebook? Do I also have to have... Okay. Well, regardless, she's an impressive person, and 7 children, and being able to... So, it's just crazy. Anyways, I'm gonna mark all this off, and I'm gonna say in here in the personal life that it is likely that she has a very supportive community that she has built that support her as well as she supports them. And I think that that's fair. I think that's a good thing. Okay. With that, I would like to thank you for joining me in the 3 parts, if you have, on researching Amy Coney Barrett. I'm going to try and make these notes available from the YouTube video. I'm not sure how I'm going to do that right now, but I will try my best. And if you can't find them, or if I haven't given a link, then maybe you could pause the video and like, okay, hold on. All right, check this out. There you go. There's all the notes. Pause the video, read them, write them, take a picture, screenshot it. I don't care. This is the low-tech way of communicating these. I really hope that I have a better way of communicating these to you. But that's it. I'm going to try and cut these down and make like an actual summary video and try and condense it so that people don't have to sit through 3 hours of content to do research on Amy Coney Barrett. Although I will admit that I really hope that I spoke enough to where if you wanted to listen to these while doing other things, you would still get like the major outline of who Amy Coney Barrett is. So with that, thank you, and I'll see you later.